Hello and welcome to the Blackstone Solicitors channel. Today we're discussing a topic that affects homeowners, landlords and developers alike, the right to light and air. You might be surprised to learn that your windows don't just provide a view, they can come with legal protections. If you've ever wondered whether a neighbor can build a structure that blocks your sunlight or airflow, this video will explain the law, practical considerations, and how to protect your rights. Imagine this. You've lived in your home for years, enjoying bright sunlit rooms and a steady flow of fresh air. Then, construction starts on a neighboring property. Over time, you notice the windows are in shadow, the living room feels darker, and airflow through your home is restricted. Naturally, you ask yourself, do I have a right to stop this? In England, the law recognizes both rights to light and, to a more limited extent, rights to air, which can be enforced in certain circumstances. The right to light is well established under the Prescription Act 1832. Essentially, if a window has received natural light for 20 years or more without interruption, the property owner may claim a legal right to that light. Any new building or extension that significantly reduces the amount of light entering that window could give rise to legal action. The law focuses on whether the light is sufficient for ordinary use of the room, rather than absolute darkness. The concept of a right to air is less commonly invoked but still recognized in property law. While there isn't a strict statutory right to air in the same way as there is for light, long-standing unobstructed airflow to a property may be protected under common law principles, particularly if changes by a neighbor materially affect enjoyment of the property or health of occupants. In practice, air disputes often arise alongside rights to light claims, particularly in urban areas with tightly packed buildings. Consider a homeowner whose neighbor plans a loft extension. The extension partially blocks sunlight to the living room windows. Surveyors are instructed to measure light levels, and it's found that the windows have enjoyed light for over 20 years. The homeowner can assert a claim for reduced light under the right to light, potentially negotiating compensation or alterations to the development. In a related scenario, imagine that a tall boundary fence and new extension restrict airflow into a garden and kitchen. While the right to air is less straightforward legally, a solicitor can advise on potential claims and practical remedies. Often, negotiation or mediation with the neighbor can resolve the issue without resorting to costly litigation. This is where specialist solicitors, like us at Blackstone, make a real difference. We help clients assess whether they have enforceable rights to light and, in some cases, to air, advise on the strength of claims, and guide them through practical solutions. Acting early can prevent disputes from escalating, protect property values, and save both time and stress. In summary, rights to light and air protect long-standing access to natural light and, in certain circumstances, airflow to a property. Understanding these rights is crucial, whether you're buying, selling, or planning development. The law can be complex, and professional guidance ensures you know where you stand and what steps to take to protect your home. At Blackstone Solicitors, we specialize in property, construction, and neighbor disputes. If you're concerned about a new development affecting light or airflow to your property, get in touch with our team. We'll help you understand your rights, explore your options, and take action to safeguard your home or investment. Thank you for watching. For more insights on property law, construction law, and neighbor rights, don't forget to subscribe to our channel and stay informed about your legal protections.